All right. This is going to be a California Civ Pro outline, but before I start, there are a couple of things I wanted to follow up on from the last section, and one of them is that I didn't really know how soon a defendant files a motion to remove from state court to federal district, and it says here the notice of removal must be filed within 30 days of the date defendant receives a copy of the initial pleading. If a case later becomes removable by a dismissal of a non-diverse defendant, the case may be removed within 30 days of the date it becomes removable, but for diversity cases not more than 1 year after it was brought in state court. This can be disregarded if the plaintiff acted in bad faith. Another thing I didn't know at all was it said a case based on diversity may not be removed if any defendant is a citizen of the forum state. So, I guess that's a bit rare. Anyhow, another thing I want to follow up on is the timing of pre-answer motions. The motion being in 12B, I think, is lack of jurisdiction over the subject matter that may be raised at any time, even on appeal. The lack of jurisdiction over the person, improper venue, insufficiency of process, and insufficiency of service of process. All four of those, personal jurisdiction, venue, process, and service of process, waived if not raised in the motion or the answer, whichever is first. And the failure to state a claim upon which relief can be granted and failure to join an indispensable party under Rule 19, the timing for both of those motions are anytime before trial or even at trial. Summary judgment is foreclosed on 30 days after discovery closes. And it also works with motion for, or it is the default for a motion for judgment on the pleadings. If the motion for judgment on the pleadings requires consideration of matters outside the pleadings, then it's technically a motion for summary judgment. So, and I have paged what I wanted to actually talk about, which was the standards of review, like appellate review, and when they apply. So on matters of law, an appeal, when it is alleged that the trial judge erred on a pure matter of law, the appellate court may substitute judgment for that of the trial judge, which is called a de novo review. On questions of fact in a bench trial, the trial judge will make findings of fact. The trial judge's findings of fact will not be disturbed on appeal unless they were clearly erroneous. Citing FRCP 52A6, a factual determination by the jury is afforded even greater weight on appeal. Findings of fact by a jury will be affirmed on appeal if, after viewing the evidence in light of the most favorable to affirming the jury's verdict, the reasonable jury could have reached the same conclusion. This is similar to standard a trial judge faces when deciding whether to grant a judgment as a matter of law. And on mixed questions of law and fact, are reviewed de novo. It is often difficult to determine whether the question is purely factual, purely legal, or mixed. Generally speaking, whether a set of facts meets a legal definition, for example, whether the use of copyrighted materials fair use under copyright law, is considered to be a mixed question of law and fact. And on discretionary matters is the last section, which is many decisions a trial judge makes are left to her discretion, whether to consolidate or sever cases, whether to grant leave to amend a pleading. On appeal, the standard of review is whether the judge abused her discretion in making her decision. This means that the judge's ruling will not be overturned on appeal unless it is plainly wrong or without appropriate bases. So that's going to be everything for Civ Pro from the first year outline, CMR. And I'm going to turn to California Civil Procedure. It's 7 pages. They think I'm going to read it in 30 minutes. So that's less than 1 minute a page. Let's just see how that works out. Subject matter jurisdiction of California state courts. 1 court, 2 classifications under California's unified trial system. Each of the state's 58 counties has 1 superior court that, unlike federal district courts, can exercise general subject matter jurisdiction over all civil matters except those subject to exclusive jurisdiction of another court or tribunal. The pre-unification jurisdictional distinctions between superior municipal court cases remain in the form of 2 classifications: limited civil cases and unlimited civil cases. Limited civil cases are actions in which the amount in controversy is $25,000 or less. Section 86 places restrictions on subject matter jurisdiction over equitable claims, declaratory relief actions, and requests for ancillary relief. Limited civil cases are governed by procedures entitled economic litigation for limited civil cases, limiting the pleadings, motions, and discovery available to a limited civil case litigant. Unlimited civil cases, those exceed $25,000. A full range of pleadings, motions, discovery, and equitable and declaratory relief is available in unlimited civil cases. Small claims cases, California Superior Courts have a small claims division for those limited civil cases in which the amount in controversy is generally $10,000 or less, for an action brought by an individual, $5,000 or less for actions by most other litigants. What's the difference between an individual and other litigants? Most other litigants. Small claims matters are subject to additional restrictions not applicable in unlimited and other limited civil cases. It's crazy. Amount of controversy is defined as an amount of the demand or the recovery sought, or the value of the property, or amount of the lien that is in controversy in the action, exclusive of attorney's fees, interest, and costs. California aggregation rules closely follow the federal approach in diversity cases. Reclassification. Original classification. A plaintiff filing a limited civil case complaint must note that classification in the caption of the complaint. The court clerk then classifies the action accordingly. Motion for reclassification. If an action was originally misclassified, or if it was originally correctly classified but subsequent pleadings or proceedings indicate that the classification should be altered, the Superior Court does not lose subject matter jurisdiction. Instead, a party or the court on its own motion may move for reclassification of the action. I still don't really know what original what classification even stands for. Is it one of these three types we just talked about? Oh, one court, two classifications, except there's three. And I'm supposing that's what they mean by classification. Okay, I skipped some stuff. Notice and hearing are required in making its determination. The court is authorized to consider matters beyond the demand of the complaint, including previous arbitration awards and settlement conference statements. It may not, however, consider the merits of the action. Standard for reclassification from limited to unlimited. In considering reclassification from an unlimited civil case to a limited civil case, the court must determine that the verdict will necessarily fall below the $25,000 and a penny amount in controversy required for an unlimited civil case. In other words, a recovery greater than $25,000 must be virtually unattainable. In quotes. So I'm guessing that's a term of art. Standard for reclassification from limited to unlimited. A state court may just pause 1 second. Oh, yeah. I was using my actual desk for this recording. And I think I shall actually read at my desk like a normal human. Rather than the floor. All right. More is being said. Okay, virtually unattainable. Standard for reclassification from limited to unlimited. A court will order reclassification of a limited case to an unlimited civil case when there is a possibility that the verdict will exceed $25,000. Other means, so possibility is the standard there. Believe it or not, I'm actually wanting to highlight that. And I can't. So, next thing. Other means of reclassification. Amended complaint. If the plaintiff files an amended complaint that changes the classification of the case, the clerk simply reclassifies the action as long as any required fees are paid. This is all going to California Code of Civil Procedure 403. Cross complaint. Limited civil case complaint. If the demand of a cross complaint filed in a limited civil case exceeds $25,000 or otherwise requests relief not authorized in the limited civil case, the entire action is reclassified as an unlimited civil case. The court can grant relief in any amount on the complaint and cross complaint. Unlimited civil case complaint. If a cross complaint is filed in an unlimited civil case, the entire action will retain that classification, even if the cross complaint demands $25,000 or less. The court may enter judgment on the cross complaint in any amount. That's weird. The court may enter judgment on the cross complaint in any amount. Even So let me just read that again. If a cross complaint is filed in an unlimited civil case, okay, for less than $25,000, doesn't change the unlimited classification. The cross complaint, that is. So personal jurisdiction is the next large subsection. I'm on page 2. I'm 14 minutes into this recording. Overview: for a court to exercise personal jurisdiction over the defendant, the exercise of jurisdiction must be constitutional and authorized by statute. The question of whether the exercise of personal jurisdiction violates due process, for example, whether the defendant has sufficient contacts with California that the exercise of personal jurisdiction over the defendant is fair and reasonable, i.e. minimum contacts analysis, it is the same in federal court and California state court. The constitutional aspect of personal jurisdiction is discussed in the Federal Civil Procedure Outline. Statutory authorization. California's broad long-arm statute provides a court of the state may exercise jurisdiction on any basis not inconsistent with the Constitution of the state or the United States. This is in CP 410. As explained in the Federal Civil Procedure Outline, this is an unlimited long-arm statute allowing for exercise of personal jurisdictions as long as it is constitutional. Thus, in California, the authorization by statute analysis essentially merges with the constitutional analysis. I'm on page 3. It's 16 minutes in. Venue in California state courts. Proper court. In California state courts, venue refers to the county in which an action may be tried, and proper venue may be waived if no timely objection is made. Local actions. Local actions are those involving land, recovery of real property, injuries to real property. Venue in a local action is proper in the county in which the land or some part of it is located. California Code of Civil Procedure 392A. Thus, California maintains a distinction between local actions and transitory actions that has been limited from federal practice. Transitory actions. Transitory actions are local actions and transitory actions. Those that occur, wait a minute. Transitory actions are those other than local actions. Actions against individual defendants. In transitory actions, venue is proper. General rule. If the county in which any defendant resides at the commencement of the action, if no defendant resides in venue is proper in any county. Additional proper venues. In addition to the general rule, expanded venue choices are available for some types of actions. Expanded venue for contract actions. In the county in which the obligation is to be performed or the contract was entered. Expanded venue for personal injury or wrongful death actions in the county in which the injury occurred. This is CCCP 395A. So those are additional proper venues. Contract actions where contract is entered. Personal injury, wrongful death, where the injury occurred. That's on top of the general rule. Venues proper in the county in which any defendant resides at the commencement of the action. If no defendant resides in California, venue is proper in the county. Actions against corporations, associations, and partnerships. Venue in an action against a corporation is proper in a county in which the contract is made or is to be performed, in which the obligation or liability arises, in which the breach occurs, or in which the corporation has its principal place of business. Where the contract is made or to be performed, obligation or liability arises. Breach, where the breach occurs, principal place of business. That's 5 different potential places. From 395.5. Venue and actions involving unincorporated associations or partnerships is proper in the county of the entity's principal place of business if the entity's principal place of business is on file with the Secretary of State. If no statement is on file, venue is proper in a county in which a member or partner resides. So there were 5 for corporation, unincorporated associations and all that is either its principal place of business or where the member and partners are residing. Page 4, 20 minutes in. Main relief rule. If a complaint contains one cause of action seeking more than one form of relief, venue is proper according to the rule governing the main type of relief sought. Mixed actions. In mixed actions, those actions in which the defendants or cause of action are subject to different venue rules. Main type, okay. Main relief rule when there's multiple actions. More than one form of relief. Venue is proper according to the rule governing the main type of the relief. So, mixed actions, those actions in which defendants or causes of action are subject to different venue rules. Venue generally is proper in a county in which any defendant resides unless policy, an overriding statute, or another compelling reason requires venue to be placed in a different county. If a defendant in a mixed action is entitled to a transfer of venue on one cause of action, the court must order a change of venue on all causes of action. So, I guess it's where defendant resides, unless policy or overriding statute or other compelling reason require venue to be placed in a different county. And if they transfer it for one, they transfer it for all. What does that mean? Does that mean there's no severing? Like it can't be severed? Question mark. Transfer or change of venue. Transfer for improper venue. The defendant may move for a transfer of venue to a proper county when the court designated in the complaint is not the proper court. So that's improper venue. Change of venue on other grounds. Even if original venue is proper, the court may, on motion, change venue on several alternate grounds, such as when there is reason to believe that an impartial trial cannot be had in the original county, when the convenience of witnesses and the ends of justice would not be promoted by the change, when from any cause there is no judge of the court qualified to act. Form and venue selection clauses. California courts generally enforce form selection clauses that call for action to be tried in another state as long as the clause is reasonable. Venue selection clauses will be upheld only when the chosen venue would otherwise have been permissible under an applicable statute. So then it's more than just reasonable, isn't it? Isn't it kind of more specific than that? Forum non-convenes requirement. The equitable doctrine of forum non-convenes has been codified in California. The statute permits a court to stay or dismiss an action if it finds that the action should be heard in the interest of substantial justice in a different state or county. Unlike a motion to change venue, the court of a FNC motion does not transfer the action. Rather, it declines jurisdiction to hear the case in California. In California? Wait a minute. In California? The moving party must establish that 1, the alternate forum is suitable, the defendant is subject to personal jurisdiction there, and the statute of limitations do not bar the action, and the alternate forum will provide due process and impartial judiciary and some form of remedy. And part 2 of the definition, private and public interest factors balance in favor of the alternate forum. Timing of motion, we're on page 5. It's now 26 minutes into this recording. A defendant may bring an FNC motion within the time to respond to the complaint if he has not previously generally appeared. A defendant who has filed a demurrer motion to strike is deemed to have made a general appearance unless he simultaneously files an FNC motion under 418. However, a defendant who has already filed an answer may still bring an FNC motion. Conflict of laws. Introduction. Under the Erie Doctrine, the federal court exercising diversity jurisdiction generally must apply the law of the state in which it sits. Thus, California's substantive law, along with California's conflict of laws rules, will sometimes apply in federal court. California conflict of laws rules are described below. For more general details on the Erie Doctrine, see Federal Civil Procedure Outline. California conflict of law rules. In contrast to several other states, California has abandoned the lex loci approach to conflict of laws, under which the court applies the law of the place of the wrong. California resolves conflict laws issues using the following approaches. Tort actions, governmental interest approach. Contract actions, choice of law clauses. So, the court first determines in a tort action whether the laws of the 2 or more states are identical. If they are not, the court evaluates whether each state has an interest in the application of the law. So this is a step-by-step analysis. 1, is the law identical? 2, whether each state has an interest in the application of its law. If each state has such an interest, a true conflict exists, and the court then analyzes the comparative impairment to each state's interest should the law of the other state be applied. Contract actions. Choice of law clauses. If the choice of law clause in a In a contract encompasses all causes of action, the court must determine whether the clause is enforceable by examining whether the chosen state's law has a substantial relationship to the parties or their transaction or any other reasonable basis, whether the chosen state's law conflicts with a fundamental California policy. If such a conflict exists, the court must decide whether California has a materially greater interest than the chosen state in the determination of the specific issue. If the contract does not contain a choice of law clause, or if the clause is unenforceable, the court generally will apply the governmental interest approach to determine which state's laws govern the contract. Washington Mutual Bank, FA versus Superior Court. So I think I missed the first step here. Whether the clause is enforceable, whether the chosen state's law has a substantial relationship with the parties or their transaction or any other reasonable basis exists for the party's choice of law. If the clause is enforceable, then assesses whether the chosen state's law conflicts. And if so, who has a greater interest? So it's a 5-part test here. Oh, I'm learning law for the first time 5 days out of the exam. Pre-trial and trial procedures. Commencement of the action. Page 6. 31 minutes into this. In California state courts, in federal court, an action is commenced by filing a complaint with the court. This is under 411.10. The filing stops the running of the statute of limitations. It does. Oh, tolls. Does it toll? Complaints toll. Just made that up because it doesn't say it here. The courts may adopt local rules or apply statewide rules to permit filing by fax or other electronic means. Statute of limitations in California courts. The California Code of Civil Procedure sets out a collection of statutes of limitation governing a variety of causes of action. And we see CCCP 315 to 349. Identifying the statute of limitations applicable to a cause of action requires determining the gravamen of the cause of action. Underlying injuries and not the legal theories or recovery sought dictate the applicable statute. In order to avoid the bar of the statute of limitations, the plaintiff must file a complaint within the statutorily specified time after the cause of action has accrued. Accrual of cause of action. Generally, a cause of action accrues when the plaintiff has suffered actual and appreciable harm. If the plaintiff has not discovered that she has been injured, the accrual of the cause of action may be delayed until the plaintiff suspects or should suspect that her injury was caused by wrongdoing. That's Jolly versus Eli Lilly and Company, 1988. I haven't been giving case citations, but for the ones that say bank, I'm giving this one just because the name Jolly is cool. And actually because I think it's kind of, it amuses me. Tolling of statute of limitations. The statute of limitations may be tolled for various statutory reasons, such as while the plaintiff is a minor or incarcerated. Additionally, the statute of limitations may be subject to equitable tolling, which suspends the running of the statute in the interest of fairness as long as the defendant is not prejudiced. Service of process. Who may serve? As in federal court, any person who is at least 18 years old and not a party to the action may serve the summons and complaint together in this process. This is cool because I actually, I know this, I read this because I was answering a exam question and I used the book because I knew nothing about civil procedure in California. Parties served within California. I didn't record it though, so I'm going to just read it again. It's not that long. California statutes authorize several methods of service of process on defendants within California, including personal delivery, substitute service, which is leaving a copy of summons and complaint at authorized locations with specific individuals, followed by mailing. Third, service by mail. Fourth, service by publication. For service on defendants outside California, in addition to using a proper method, service must be made on an appropriate person. Not a party. Remember, not a party, at least 18, okay. These are a process. Notice of acknowledgement of service. Similar to federal practice, the plaintiff in a California state court may mail the summons, complaint, and notice and acknowledgement of receipt of summons to the defendant. If defendant does not return the acknowledgement within 20 days of mailing, he is liable for plaintiff expenses in serving defendant by other method. In contrast to federal procedure, the return of the acknowledgement does not extend a California defendant's time to respond to the complaint. So there's no waiver? No benefit of waiver. There may very well not even be a waiver. If the defendant does not return the acknowledgement in 20 days, he's liable for expenses. Okay, whatever. Parties served outside the state, but within the United States. In addition to methods authorized for service on in-state defendants, service of process on a party outside California may be made by sending summons and complaints by first-class mail, postage prepaid, requiring a return receipt. Even if service is successfully completed, a proper statutory and constitutional basis must exist for the exercise of personal jurisdiction over a defendant not present in the state. Fourth, parties served in a foreign country. In addition to a manner authorized for in-state service, service outside the United States may be made, 1, as the court directs, or 2, if the court finds that the service is reasonably calculated to give actual notice as directed by the law or of the place where the person is served, or by a foreign authority in response to a letter request. An international treaty, such as the Hague Convention, may govern service in signatory countries. No immunity from process. California does not grant immunity from service of process for non-resident individuals temporarily present in the state to participate in litigation. Despite the abrogation of immunity in California, most federal courts sitting in diversity would apply the traditional federal immunity. Interlocutory injunction. An injunction is an equitable remedy by which a person is ordered to act or refrain from acting in a specified manner. Preliminary injunction. A preliminary injunction is sought by a party prior to a trial on the merits of the complaint. A preliminary injunction may not be issued without notice to the adverse party. The party seeking the preliminary injunction must demonstrate a likelihood of prevailing on the merits, as well as irreparable harm if the injunction is not issued. Temporary restraining order. A temporary restraining order is granted by a court when it is necessary to prevent irreparable injury to a party, and the injury will result before a preliminary injunction hearing can be held. Requirements for ex parte temporary restraining orders. So far, is there anything different? requirements for ex parte temporary restraining orders. Generally, notice of a hearing for the issuance of a TRO must be given before a TRO is issued. However, the court may grant a TRO without notice of a hearing to the adverse party if 3 requirements are met. Following facts, specific facts showing immediate or irreparable injury. The moving party must give specific facts in an affidavit or a verified complaint to, haven't heard that term, verified complaint, to establish that immediate and irreparable injury will result to the moving party before the adverse party can be heard in opposition. Efforts to give notice, the moving party must certify in writing all efforts have been made to give notice to the adverse party and the reasons why notice should not be required. Security, the court has discretion to issue TRO without a bond or undertaking. In contrast, the court must require an undertaking for the issuance of a preliminary injunction. Notice of hearing versus actual notice. Although a TRO may be issued without notice of hearing, due process requires that a person must receive actual notice of TRO or any other injunction for that matter before he may be held in contempt for violating it. Discretion of court, that's all the same. Discretion of court, even if the above requirements are met, the court still has discretion whether to issue the TRO. The court may look at the likelihood that the plaintiff will prevail on the merits. Also, the court may weigh the injury anticipated by the moving party against the harm caused by issuing the TRO. Time limit, the TRO expires automatically when a preliminary injunction is either issued or denied. If no notice is provided to the opposing party, the court will set a hearing on the application for a preliminary injunction within 15 days of the issuance of the TRO or 22 days if good faith is shown. All right. 15 days, 22 days, and there's good cause. So I'm ending at pleadings at 42 minutes on page 8 just because I can't take it